License and registration. Of course, officer. May I ask why you pulled me over? You were driving 5 miles over the speed limit. Registration now. Here's my registration. And my license. I'm Judge Dan Harper. I sit on the U.S. District Court. I'm driving to court for a 9am hearing. This vehicle is registered to a Dan Harper. How do I know you're that person? My driver's license has my photo, my name, and my signature. My federal judicial credentials are in my briefcase. Step out of the vehicle. I need to verify this car isn't stolen. You're asking me to exit my vehicle for going 5 miles over the speed limit. Mom, are you refusing to comply with a lawful order? Officer Randall Pierce had been with the Prince George County Police Department in Maryland for 10 years when he walked into a situation that would destroy his career and cost the county $6.2 million. He was 36 years old, experienced enough to know that minor traffic infractions don't justify vehicle searches and prolonged detentions, but apparently convinced that a black woman driving a Mercedes couldn't possibly be the legitimate owner. One Wednesday morning on Route 50 near the Federal Courthouse in Greenbelt, Maryland, he pulled over a vehicle for allegedly exceeding the speed limit by 5 miles per hour and decided the driver must have stolen the car. The driver was Judge Dan Harper, the U.S. District Court Judge for the District of Maryland, driving to court to preside over a trial involving excessive police force. What Pierce did next, ordering her from her vehicle, demanding proof of ownership despite valid registration, detaining her for 47 minutes while running warrant checks and calling for K-9 units, would become the subject of a federal civil rights lawsuit that exposed how a police department allowed an officer with 23 complaints to continue making traffic stops. Dan Harper's career wasn't affected. Randall Pierce's career ended, and Prince George County would pay $6.2 million to prove that even federal judges aren't protected from officers who see black drivers as automatically suspicious. A black woman in her late 50s, Judge Dan Harper, was driving east on Route 50 at 8:17 am in her silver Mercedes E-Class, wearing her judicial robe over a charcoal suit, with her briefcase containing case files on the passenger seat beside her. She was driving 60 miles per hour in a 55 zone, 5 miles over the limit along with most of the morning commuter traffic. No reckless driving, no weaving, no danger. Just a federal judge heading to work to preside over a police misconduct trial. But Officer Pierce saw her through assumptions honed over 10 years of stops that followed the same pattern. Black drivers in NASCARs were assumed to be driving stolen vehicles. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. Route 50 runs through Prince George County, Maryland, connecting Washington, D.C. to Annapolis. The stretch near Greenbelt is a major commuter corridor, 4 lanes in each direction with a speed limit of 55 miles per hour that most drivers exceed during morning rush hour. Traffic flows at 60-65 miles per hour routinely. The road passes through suburban communities, office parks, and federal facilities including the U.S. District Courthouse for the District of Maryland in Greenbelt. The courthouse sits just off Route 50, a modern building completed in 1994 that handles federal trials, hearings, and proceedings for the southern half of Maryland. Federal judges, magistrates, attorneys, and court staff commute to this courthouse daily from throughout the Washington metro area. On any Wednesday morning, the route is busy with federal employees heading to work, attorneys driving to court, witnesses traveling to testings. The kind of commute that happens thousands of times weekly without incident. Date was 8:17 am on a Wednesday in November. The temperature was 52 degrees with overcast skies. Morning rush hour was in full flow. Traffic moved steadily at 60-65 miles per hour. Hundreds of vehicles heading east toward federal facilities and west toward D.C. The kind of routine Wednesday morning commute where nothing should go wrong. Until Officer Pierce decided a black woman in a Mercedes needed to be stopped. Judge Dan Harper had been a U.S. District Court Judge for the District of Maryland for 12 years. 12 years of presiding over federal trials, criminal prosecutions, civil rights cases, and complex litigation. She'd handled over 850 cases, presided over 127 trials, and written hundreds of judicial opinions. Her legal reasoning was cited by the Fourth Circuit Court of Appeals regularly. Her trial management was efficient and fair. Her evidentiary rulings were consistently upheld on appeal. She'd never been reversed for legal error in 12 years on the bench. The legal community in Maryland knew her work. She'd presided over high-profile cases involving government corruption, environmental violations, police excessive force, and white-collar fraud. She'd sentenced public officials to prison for corruption. She'd ruled against the federal government in civil rights cases. She'd granted qualified immunity to police officers when the law required it and denied it when officers clearly violated established rights. Her judicial philosophy was straightforward: follow the law, protect constitutional rights, ensure fair trials. Both prosecutors and defense attorneys respected her fairness. Government lawyers and civil rights attorneys acknowledged her careful legal analysis. Even parties who lost in her courtroom recognized the quality of her reasoning. Harper had graduated from Spelman College in 1987 with a degree in political science, graduating summa cum laude. She'd been student government president, editor of the college newspaper, and recipient of the Presidential Award for Academic Excellence. She'd then attended Yale Law School, one of the few black women in her class. She'd excelled despite facing isolation and occasional discrimination. Law Review in her second year, executive editor in her third year. Graduation with honors in 1990. Her Law Review article on Fourth Amendment protections during traffic stops was cited in a Supreme Court opinion and taught in constitutional law courses across the country. After law school, Harper clerked for Judge Constance Baker Motley of the Southern District of New York, a legendary civil rights attorney who'd worked with Thurgood Marshall and argued cases before the Supreme Court before becoming a federal judge. That clerkship shaped Harper's entire understanding of the law's power to protect civil rights. Judge Motley taught her that judicial opinions had consequences for real people, that constitutional protections meant nothing without judges willing to enforce them, and that fairness required judges to check their own biases constantly. Harper then spent 18 years at the Department of Justice Civil Rights Division, litigating voting rights cases, police misconduct cases, housing discrimination, and education equality. 18 years of fighting for constitutional rights in federal courts across the country. She'd litigated pattern and practice investigations of police departments. She'd sued municipalities for systematic civil rights violations. She'd enforced the Voting Rights Act against states that discriminated against minority voters. She'd argued 17 cases in federal courts of appeals and won 15. She'd argued one case before the U.S. Supreme Court and won. Her litigation record was exceptional. Her reputation for thorough preparation and principled advocacy was known throughout the Justice Department. In 2008, President Bush nominated her to the U.S. District Court for the District of Maryland. The American Bar Association rated her unanimously well qualified, their highest rating. The Senate Judiciary Committee held hearings where both Republican and Democratic senators praised her qualifications. She was confirmed 89-9 with overwhelming bipartisan support. She became one of the few black women federal judges in the country. At 45 years old, she'd reached the culmination of a career dedicated to justice and civil rights. As a district court judge, Harper had presided over cases that shaped Maryland law and federal precedent. She'd written an opinion on Fourth Amendment protections during traffic stops that was cited in the Fourth Circuit and other circuits. She'd presided over a police excessive force trial that resulted in a $4.7 million verdict against the county. She'd handled complex patent litigation, environmental cases, and criminal prosecutions. She'd sentenced drug traffickers, white-collar criminals, and corrupt officials. She'd dismissed cases when prosecutors couldn't meet their burden. She'd granted habeas corpus petitions when convictions were constitutionally flawed. She'd managed her docket efficiently, deciding motions promptly and moving cases to trial without unnecessary delay. She was mentioned in legal journals as a model trial judge. Harper lived in Chevy Chase, Maryland, a suburb just outside Washington, D.C. She'd purchased her home in 2009, a colonial and a quiet neighborhood. She'd lived there for 15 years. Her commute to the Greenbelt Courthouse was 35 minutes via Route 50. She made this drive hundreds of times per year. She drove a 2021 Mercedes E-Class, purchased new and registered in her name. The car was paid off. She maintained it meticulously. She'd never received a speeding ticket in that vehicle. She drove carefully, aware that as a federal judge, her conduct both on and off the bench reflected on the judiciary. That Wednesday, November 15th, Harper had a trial scheduled to begin at 9:30 a.m. A civil rights case alleging excessive force by county police officers during a traffic stop. The plaintiff, a black man, alleged he was pulled over without cause, ordered from his vehicle at gunpoint, and beaten when he questioned the officer's authority. The defense argued the officers had reasonable suspicion and used appropriate force when the plaintiff resisted. Harper had reviewed the briefs, watched the body camera footage, and studied the case law. She was prepared. She'd left her home at 7:55 am to arrive at court with time to review final motions before the trial began. She drove east on Route 50 at the prevailing speed of traffic, approximately 60 miles per hour in a 55 zone. She wore her judicial robe over her suit to save time when she arrived at court. Her federal judicial credentials hung on a lanyard around her neck. Her briefcase sat on the passenger seat with the trial files. She looked exactly like what she was, a federal judge driving to court. She'd done nothing unusual. She'd committed no serious traffic violation. She was flowing with traffic at the same speed as dozens of other vehicles. But Officer Pierce saw her and decided to stop her. Officer Randall Pierce had been with the Prince George County Police Department for 10 years. 10 years of traffic enforcement with a complaint record that documented a clear and disturbing pattern. Pierce's stops weren't random. They followed a consistent theme. Black drivers in expensive vehicles were assumed to be driving stolen cars or involved in drug trafficking. His first complaint came in year 1, June 2014. A black businessman, Robert Jackson, was stopped while driving his BMW to work. Pierce questioned him extensively about how he could afford the vehicle, demanded proof of ownership beyond the registration, and detained him for 35 minutes while running checks for stolen vehicle reports. Jackson owned the car. He'd purchased it new 2 years earlier. He was a vice president at a tech company. Complaint sustained. Diversity training assigned. Year 2, October 2015. A black doctor, Angela Williams, was stopped while driving her Lexus SUV. Pierce asked her multiple times whether the vehicle was hers, questioned how a woman her age could afford such an expensive car, and suggested she must be a drug dealer's girlfriend. Williams was a cardiologist at Johns Hopkins. She'd purchased the Lexus with her own money. Complaint sustained. Cultural competency workshop required. Year 3, March 2016. A black attorney, Marcus Henderson, was stopped for allegedly failing to signal a lane change. Pierce searched his Mercedes without consent, claiming he smelled marijuana though no drugs were found. Henderson had never used drugs. He was a partner at a major D.C. law firm. Lawsuit filed. County settled for $85,000. Pierce received a written warning. Year 4, July 2017. A black family, the Thompsons, were stopped while driving to their daughter's college orientation in their Audi Q7. Pierce detained them for 52 minutes, questioned the teenage daughter about whether her parents were really her parents, and called for K-9 units to search for drugs. No drugs were found. The family missed their orientation appointment. Complaint sustained. Supervisor counseling conducted. Year 5, November 2018. A black college student, Jordan Mitchell, was stopped while driving home from his job at a consulting firm in his Honda Accord. Pierce accused him of driving a stolen vehicle despite valid registration. Jordan had purchased the car from his savings. Pierce held him for 41 minutes until he could produce purchase documents from his apartment. Complaint sustained. Additional implicit bias training required. The pattern was undeniable. Black drivers in any vehicle nicer than Pierce believed they should own were stopped, questioned, detained, and accused of theft or drug trafficking. Each complaint documented the same behavior. Pierce seeing black success and assuming criminality. By year 6, Pierce had 14 complaints. By year 7, 17. By year 8, 20. By year 9, 22. By year 10, 23 complaints total. 19 involving assumptions that black drivers in NASCARs were criminals. 11 sustained. 8 dismissed as judgment calls. For still under investigation. His supervisors documented the pattern in annual reviews. They noted he needed better judgment on when vehicle searches were appropriate. They recommended he focus on serious violations rather than pretextual stops. They suggested he might benefit from assignment away from highway patrol, but they never removed him from traffic enforcement. They never imposed meaningful discipline beyond training. They kept assigning him to Route 50 where his bias created constitutional violations and lawsuits. On the morning of November 15th, Pierce was running radar on Route 50 near the Greenbelt Courthouse exit. At 8:17 am, he clocked a silver Mercedes E-Class at 60 miles per hour in a 55 zone. Dozens of vehicles were traveling at the same speed. Pierce could have stopped any of them. He chose the Mercedes. He pulled behind it, activated his lights, and initiated the stop. He saw the driver as the Mercedes pulled to the shoulder. A black woman in what appeared to be professional attire. His 10-year pattern of assumptions activated immediately. Black woman, expensive car, must be stolen or connected to drugs. He exited his patrol car and approached the driver's window. License and registration. Harper had seen the lights behind her and pulled over immediately, confused about why she was being stopped. She'd been going the same speed as surrounding traffic. She rolled down her window and spoke calmly. "Of course, officer. May I ask why you pulled me over?" "You were driving 5 miles over the speed limit." "Registration now." Harper reached for her glove compartment slowly, retrieved her registration, and handed it to Pierce along with her driver's license from her purse. "Here's my registration and my license. I'm Judge Dan Harper. I sit on the U.S. District Court for the District of Maryland. The courthouse is 2 exits from here. I'm driving to court for a 9 a.m. trial. This vehicle is registered to a Dan Harper." "How do I know you're that person?" Harper pointed to her license. "My driver's license has my photo, my name, and my signature. My federal judicial credentials are in my briefcase on the passenger seat if you need additional verification." "Step out of the vehicle. I need to verify this car isn't stolen." This is where a minor traffic stop becomes a constitutional violation. Pierce had valid registration showing the car belonged to Dan Harper. He had a driver's license with her photo matching her face. He had no reasonable suspicion the vehicle was stolen. He had no legal basis to order her from the vehicle. But his assumption, black woman in expensive car equals stolen vehicle, overrode the evidence in his hands. Harper's judicial training told her this was unlawful, but she also knew refusing could escalate dangerously. "Officer, you're asking me to exit my vehicle for going 5 miles over the speed limit. You have my registration proving I own this car. You have my license proving my identity. Mom, are you refusing to comply with a lawful order?" This is where bias becomes impenetrable. Pierce had no lawful basis to order her from the vehicle, but he'd framed it as a lawful order to make her refusal seem like obstruction. Another vehicle pulled to the shoulder behind Pierce's patrol car. FBI Special Agent Thomas Martinez was driving to the same courthouse for a case he was testifying in that morning. Martinez had worked with Judge Harper on cases where he'd testified about federal investigations. He recognized her Mercedes from the courthouse parking lot. He saw Pierce ordering her from the vehicle, and immediately understood something was wrong. Martinez exited his vehicle and approached, his FBI credentials visible on his belt. Harper remained calm, her voice carrying judicial authority honed back 12 years on the bench. "Officer, I am not refusing to comply with lawful orders. I'm questioning whether ordering me from my vehicle for a minor speeding infraction is lawful when you have my valid registration and license. I'm a federal judge. I'm expected in court. I'm happy to accept a speeding citation, but I don't believe exiting my vehicle is legally required." Pierce's voice rose. "Mom, I'm conducting a traffic stop. I have the authority to ask you to step out for officer safety." Martinez reached them. "Officer, I'm FBI Special Agent Thomas Martinez." He held up his credentials. "That's Judge Diane Harper, U.S. District Court. She presides in the courthouse 2 miles from here. I recognize her vehicle from the federal parking lot." Pierce turned annoyed. "Sir, this is a traffic stop. Please return to your vehicle." Martinez's voice carried federal law enforcement authority. "Officer, I'm telling you that's a federal judge. I've testified in her courtroom. Her credentials are legitimate. This stop needs to end." A second witness, attorney Sarah Klein, was driving to the same courthouse for the same trial. Klein was representing the plaintiff in the excessive force case. She'd appeared before Judge Harper dozens of times. She saw the traffic stop and Harper's Mercedes and pulled over concerned. She exited her vehicle and approached. Pierce ignored Martinez and focused on Harper. "Mom, I need you to step out of the vehicle now or I will physically remove you." Harper checked her watch. 8:24 a.m. She needed to be in her chambers by 8:50 to review final motions. This stop was already eating into her preparation time. She made a decision. She would comply to avoid escalation, but document everything for the complaint she would file. She exited her vehicle. Pierce immediately moved her toward the back of her car. "Place your hands on the trunk." Martinez's voice sharpened. "Officer, what is your probable cause for a search?" Judge Harper was going 5 over. "That doesn't justify a vehicle search," Klein called out, approaching them. "That's Judge Harper. I'm an attorney. She's the judge assigned to my trial this morning. This stop is unlawful." Pierce ignored both of them. "Mom, do you have anything illegal in this vehicle? Drugs, weapons, stolen property?" Harper's voice was ice. "Officer Pierce, I am a federal judge. I have nothing illegal in my vehicle. This is my car, purchased and registered in my name. You have no probable cause to search it. This stop is unconstitutional and everything you're doing right now will be documented in the federal lawsuit I will file. Do you think officers who conduct unconstitutional searches should face criminal prosecution? Drop your answer below." Pierce opened Harper's trunk without consent. He searched through her gym bag, her emergency kit, her spare tire compartment. He found nothing. He moved to the passenger area, opened the door, and began searching her briefcase. Martinez pulled out his phone and started recording. "Officer, you are searching a federal judge's vehicle without probable cause or consent. This is being documented." Klein was also recording on her phone. "Officer, I'm an attorney. This is an illegal search. Judge Harper has rights." Pierce pulled case files from Harper's briefcase. He saw the federal court seal on the documents. He saw U.S. District Court, District of Maryland printed on the headers. He saw Honorable Diane Harper, District Judge on the case caption. For the first time, doubt flickered across his face. He'd been so certain this was a stolen vehicle or a drug courier that he'd ignored every piece of evidence to the contrary. A supervisor, Captain James Wilson, arrived at 8:41 am, 24 minutes after the initial stop. Wilson had been called by dispatch when Martinez reported federal judge detention on Route 50. Wilson was a 23-year veteran who'd worked with federal judges on joint task forces. He knew Judge Harper by reputation. He exited his vehicle and approached the scene, his face tight with concern, when he saw Harper standing beside her vehicle while Pierce searched through her files. Wilson's voice was sharp. "Officer Pierce, what is the basis for this stop and search?" "Traffic violation." Subject was suspicious. "Checking for stolen vehicle or contraband." Wilson looked at Harper and recognition was immediate. "Judge Harper." Harper's voice was controlled but carried unmistakable authority. "Captain Wilson, Officer Pierce pulled me over for allegedly driving 60 in a 55 zone. Despite my providing valid registration and license, he ordered me for my vehicle, accused me of driving a stolen car, and is currently searching my briefcase without probable cause or consent. FBI Special Agent Martinez and Attorney Klein have witnessed and recorded this entire encounter. I've been detained for 24 minutes for a minor traffic infraction." Wilson's face went pale. "Officer Pierce, cease the search immediately. Return Judge Harper's belongings to her vehicle." Pierce started to protest. "Captain, I have discretion to." "You have no discretion to conduct warrantless searches without probable cause. You have no discretion to detain a federal judge for 24 minutes over 5 miles per hour. Return her belongings now." Pierce reluctantly placed Harper's files back in her briefcase. Wilson approached Harper. "Judge Harper, I apologize on behalf of Prince George's County Police Department. This stop was inappropriate. You're free to go. No citation will be issued." Harper's voice was final. "Captain Wilson, I want Officer Pierce's body camera footage. I want the dash camera footage. I want a complete incident report. I want his personnel file including complaint history. And I want all of it delivered to my chambers by 5 p.m. today." Wilson nodded. "You'll have everything, Your Honor." Harper got back in her vehicle. Martinez and Klein returned to their cars. The time was 8:43 am. She'd been detained for 26 minutes. She drove directly to the courthouse, arriving at 8:46 am, 4 minutes before she'd planned. She went straight to her chambers, briefed her law clerks on what had happened, and instructed them to begin researching her legal options. Then she reviewed her trial files and at 9:30 am, she took the bench and presided over a trial about excessive police force during a traffic stop. The irony wasn't lost on anyone in the courtroom. Within 3 hours, the videos from Martinez and Klein were shared with courthouse staff and local media. Multiple angles showing Pierce searching Harper's vehicle. Clear audio of Harper identifying herself as a federal judge. Clear audio of Pierce demanding to search for drugs and stolen property. The videos went viral by evening. Legal organizations expressed outrage. The Chief Judge of the District of Maryland issued a statement condemning the stop. The Maryland NAACP demanded immediate termination and federal investigation. Every federal judge organization in the country issued statements of support. The headlines were devastating. Prince George's cop detains federal judge for 26 minutes over minor speeding. U.S. District Judge search without cause during traffic stop. Officer with 23 complaints stops federal judge driving to court. The FBI opened a federal civil rights investigation within 24 hours. The U.S. Attorney for the District of Maryland reviewed for potential federal charges. The county executive called Judge Harper to apologize personally. The police chief announced Pierce was on administrative leave. Judge Dan Harper filed a federal civil rights lawsuit 14 weeks later. The suit named Officer Randall Pierce, Captain James Wilson for supervisory failure, and Prince George's County. The claims were extensive. Unlawful detention without reasonable suspicion for extended period. Illegal search without probable cause or consent. Racial profiling in violation of the 4th and 14th Amendments. Violation of civil rights under 42 U.S.C. 1983. Intentional infliction of emotional distress. interference with federal judicial duties, failure to train and supervise officers with documented patterns of racially biased stops. The county settled within 14 months. $6.2 million to Judge Dan Harper. Officer Randall Pierce was terminated 22 weeks after the incident. The termination letter was final and damning. Officer Pierce detained U.S. District Judge Diane Harper for 26 minutes for a minor traffic infraction, ordered her from her vehicle without legal justification, accused her of driving a stolen car despite valid registration, and conducted an illegal search of her vehicle and personal belongings without probable cause or consent. Despite Judge Harper's identification, despite FBI Special Agent confirmation, and despite an attorney witnessing the constitutional violations, Officer Pierce continued the unlawful detention and search. This incident represents the culmination of 23 complaints documenting a pattern of assuming black drivers in expensive vehicles are engaged in criminal activity. Despite multiple training interventions, Officer Pierce's behavior remained unchanged. His employment is terminated immediately. Pierce's name was entered into the National Decertification Index. His law enforcement career was over at 36 years old. Should officers who illegally search vehicles face automatic termination? Let me know what you think. The Department of Justice Civil Rights Division opened a pattern and practice investigation of Prince George County Police traffic enforcement. The findings confirm systemic failures. 23 complaints over 10 years. 19 involving assumptions that black drivers in NAS cars were criminals. 11 sustained. Multiple video evidence of pretextual stops. Training interventions documented but never effective. Supervisors noting Pierce's pattern of racially disparate stops, but taking no disciplinary action. A system that documented racial profiling in traffic enforcement and did nothing. Federal reforms were mandated. Immediate removal from traffic enforcement for any officer with 3 sustained complaints involving racially disparate stops. Mandatory data collection on all traffic stops including race, vehicle type, stop duration, and search rates. Quarterly analysis by independent auditors to identify officers with statistically significant racial disparities. Body camera and dash camera footage required for all traffic stops with automatic review of stops exceeding 15 minutes. Prohibition on vehicle searches based solely on officer discretion without articulable probable cause. Independent civilian oversight of traffic stop complaints. Judge Diane Harper testified before a congressional hearing on racial profiling in traffic enforcement 9 months after the incident. Her testimony was measured, precise, and devastating. I am a United States District Court judge. I have served on the federal bench for 12 years. I have presided over cases involving Fourth Amendment violations. I have ruled on motions to suppress evidence from illegal searches. I understand the constitutional standards for traffic stops and vehicle searches, and none of that knowledge protected me from being detained for 26 minutes and illegally searched on my way to court. She paused. Officer Pierce saw a black woman driving a Mercedes and assumed the car was stolen. Despite my valid registration, despite my driver's license, despite my identification as a federal judge, despite an FBI agent confirming my identity, he searched my vehicle looking for drugs and stolen property because he could not accept that a black woman legitimately owned that car. Another pause. 23 complaints in 10 years. 19 involving the exact same assumption that black drivers in expensive vehicles are criminals. 11 sustained with evidence proving the stops were pretextual. And Prince George County's response was to send him to diversity training and put him back on traffic patrol, where he continued the same behavior for 10 years. Her voice remained judicial but carried authority. The county is paying $6.2 million. That's accountability. Officer Pierce was fired. That's consequences. But money and termination don't undo being treated like a criminal on your way to work. They don't erase the humiliation of having an FBI agent and an attorney witness a federal judge being searched for drugs. They don't restore the 26 minutes I lost preparing for a trial about police excessive force during traffic stops. She looked at the congressional committee. If this can happen to me, a federal judge with FBI agents and attorneys witnessing the violation, what happens to black drivers without my position? What happens to black professionals who can't call the chief judge? What happens to black families stopped and searched because officers don't believe they can afford their cars? What happens when departments document patterns of racial profiling and respond with training instead of termination? The hearing room was silent. Should traffic stops exceeding 15 minutes for minor infractions trigger automatic supervisory review? Drop your answer. This wasn't about one officer's bias. This was about a system that allowed Randall Pierce to accumulate 23 complaints over 10 years, 19 documenting the exact same pattern of assuming black drivers were criminals, and responded with nothing but training that accomplished nothing. It was about supervisors who wrote in evaluations that Pierce had high rates of vehicle searches with low contraband recovery rates, who noted his stops disproportionately involved black drivers in expensive cars, who documented complaints from professional black drivers, and then assigned him right back to highway patrol. 23 complaints, 19 involving racial assumptions about vehicle ownership, 11 sustained with evidence proving the stops were pretextual or the searches were illegal, multiple settled lawsuits, multiple training workshops, multiple counseling sessions, and 0 meaningful consequences until he stopped a federal judge who had the legal knowledge to recognize the constitutional violations and the authority to demand accountability. The pattern was documented. The racial disparity was statistically significant. The department's response was inadequate. They chose protecting Pierce over protecting drivers. They chose training over termination. They chose documentation over discipline. Until Pierce's assumptions targeted someone who understood the law well enough to articulate exactly how it was violated. Randall Pierce's career is over. That's justice. The county paid $6.2 million. That's accountability. The DOJ imposed reforms. That's oversight. But settlements and policies don't undo constitutional violations. They don't restore dignity. They don't erase the message that black drivers will be assumed criminals regardless of their credentials or actual ownership. The real question is what changes now. Do police departments finally remove officers after 3 sustained racial profiling complaints instead of 23? Do supervisors finally act on statistical evidence of racial disparities instead of assigning more training? Do we finally acknowledge that pretextual stops of black drivers in NASCARs are racial profiling, not legitimate law enforcement? Because if we don't fix the systems that kept Pierce on traffic patrol despite 23 complaints and 11 sustained findings, if we don't address the culture that assumes black drivers can't legitimately own expensive vehicles, then we're just waiting for the next officer, the next pretextual stop, the next black driver detained and searched for existing, while successful, the next federal lawsuit proving the pattern never changed. Comment if you believe this should be federal law. Police departments with officers showing statistically significant racial disparities in traffic stops must remove those officers from traffic enforcement and face Department of Justice oversight if disparities continue. And if you think these stories need to be told, if you believe accountability starts with awareness and change starts with pressure, then hit that subscribe button. We're not stopping. We're going to keep exposing these patterns. We're going to keep demanding better. We're going to keep fighting for the federal judges, the professionals, the families, the ordinary drivers who deserve to travel without being presumed criminals. This isn't just about one officer or one judge. It's about all of us and the system we're willing to accept.